Okay, so the first clause we're going to discuss is on page 341, known as insurance condition arranging insurance. Now the actual clause states that this offer is conditional on the buyer arranging insurance for the property satisfactory to the buyer and the buyer's sole and absolute discretion. So that literally means that the buyer has to be fully satisfied with it, he has to like it, he has to be into it, he has to be okay with the terms and the rates and whatever the penalties are if there's any in that application. And then it continues to say, unless the buyer gives notice in writing delivered to the seller personally or in accordance with any of the provisions of the delivery of the notice in this agreement of purchases and sale. So the seller would have to issue a notice, which the seller, if he's working with his own agent, his agent can issue a written notice by fax or email. Or also, you can also do a notice where the seller's written a letter directly to the seller has written notice to the buyer that in accordance with the other provisions, so that if the delivery is not made at that point, then it's up to the seller to, within the time period, so it's going to be on a day of and a time of, that its condition has to be fulfilled by. Now, if that condition does not happen, then the offer is null and void, which means it dies, and then the deposit is returned completely to the buyer without any deduction, so he would receive his deposit that's sitting in trust with the real estate office or the lawyer, depending upon the scenario. But in the case of the real estate agents being involved, it would be sitting in trust with a real estate office. Now the seller agrees to cooperate to in providing access to the property if necessary, because if there's an inspection requirement for the insurance by any type of insurance inspector, home inspector, or whatever the case is, the seller has to cooperate. If he doesn't cooperate, then that of course can turn into other liabilities for the seller. The condition is included for the benefit of the buyer and may be waived by the buyer's sole option. So here what we've done is done a legal coverage where we have legally confirmed and looked over so that there isn't going to be any issues for the buyer. He can understand that it's for his benefit. He doesn't have to obviously waive the condition until he's completely happy in writing to the seller, and then it has to be within the time period that is stated within. Okay, so that covers your insurance clause condition of arranging. The second clause is arranging insurance and the cost is not to exceed. This is an extent where, of course, you are dealing with a buyer who has a really strict budget, and because of that strict budget, it could be a deal breaker. You really don't want to use clause number 2 unless you have those particulars. So if the yearly cost can't exceed, $1,500 or $2,000 or whatever the case is, that will go right into this clause, known as Insure Clause 2. It falls on page 342 as well. And in that clause, you would actually just enable it to state what type of cost is the limitation for that. Okay. We can also look at page 344. That is known as Heritage 1 clause. This is for obviously Interior Heritage Act designation, so you have to have a property that is known as a historic property or heritage property. It's going to fall under the provisions of Ontario Heritage Act, and of course you have to acknowledge that the buyer is aware of this, because this includes a huge amount of restrictions in terms of renovation and reconditioning of the property. So there has to be certain things and guidelines that have to be met before they can go ahead and do anything in that respect. Okay, so then we'll look at another clause, which is power of sale provision. Power of sale general provisions on page 348. It is further understood on the date of acceptance of this offer that there's a default under the terms of charge or mortgage. So of course now there's a full disclosure happening in the first sentence of the power of sale general provision clause. It is telling you that there's a default on the property, and the only evidence of the default is which the buyer may require to show by statutory declaration by the seller, setting forth the facts and entitling the seller to sell the property under the Act. So under the Power of Sale Act, he's going to sell the properties because the person who was a buyer or the person residing in the property has not been able to make the payments. They're now in default. The seller has a right to exercise the power to, of course, continue the sale until the date of acceptance of the offer and the time of closing, as long as the person whose timeline of the buyer hasn't fulfilled to make the payments up to date. So there is obviously a provision and a date deadline for the buyer who existingly owns the home and they're in default. They'll have a certain period of time to still pay before the deal closes. So before the deal closes, if they come and pay, then of course, then the new buyer is not going to be able to buy this property. So that's all being disclosed in this clause right here. Okay. If we look further into this clause, it says that the buyer understands and agrees that the mortgagor has a right to redeem the property up to the time of waiver or expiration of all rights of termination or fulfillment of all conditions of this agreement subject to that right. So they're stating the fact that before the deal goes firm, they have the right to go back and pull the deal back and allow that person to redeem themselves and bring their payments up to date. Now, in the event of the redemption, it says, this agreement shall be null and void, and all deposits monies are refunded, obviously, and without any deduction, because there's no reason for deduction in this case. Continues on to cover that the jurisdiction prevents the completion of this sale by an interim, like a court intervenes, and they can obviously stop the sale. Then the seller is not obliged to complete the sale, the set transaction in this agreement. So if the court comes in and stops the transaction, the buyer isn't, of course, going to be out of a deal. He's not going to be able to continue with this deal. The buyer is going to receive his deposit again back without any deductions. In this event, the seller won't be responsible for any expenses or any damages incurred, because the buyer could have given 60 days notice if he's renting. He could have sold another property as a nowhere to go, and this could turn into a very big nightmare for the buyer. In this case, the seller is not financially responsible for any expenses or any losses, because he's already stated in this clause to protect himself. Last paragraph, the buyer also acknowledges that the seller makes no representation or warranties that respect to the state of the repair. So, of course, in a power of sale, it's an as-is purchase. So the way you see it, the way it is, or whatever's hidden behind it in terms of repairs are going to be the responsibility of the buyer. It's not going to have anything to do with the seller. The seller is completely got his hands up in the air and he's free and clear. He's not subject to anything. We also look at another clause here, which is ACC1. It's on page 353. It's called condition obtaining right of way. Now, this, of course, a lot of the conditions will be conditional upon the buyer obtaining, or satisfactory, or sole discretion, and so a lot of these clauses will start off in the same respect. Now, for the purposes of an easement to be created, if, say, two properties are beside each other and then they lead to the lake, but the second property is blocked by the first one, and you want to set up a right of way that gives you a path and allowance to pass over the first property to access the lake, for example, this would be a clause that might be utilized so that we can achieve that condition. And of course, that has a timeline on it, a time frame, and depending upon the condition of that property, if that's not the case, if it's not going to a committee of adjustment right away, it's going to have to go to the committee of adjustment eventually, because it's going to need a right of way to be legal and has to be approved. So this condition would be pending a further approval by the committee of adjustments. You'll also look at another condition right underneath that called road access by open public road. So this, of course, is road access where the condition, of course, is allowing automobiles to the property is by a public road and is maintained by a public expense throughout the year. This might be you might want to include this clause in the event that the road was first private and maybe it's going public. So just to give clarification and confirmation in that case. In most cases, if you're in a municipal area, it's already a public road. So it's owned by the city and operated by the city and obviously maintained by our property taxes and our state tax. Road access alternatives, you can obviously use ACC4 on page 353, and that's of course if you want to use any secondary options. If there's a year-round, it might be recreational property that has limited access or temporary access. So you can look at that. If it's a private road, turn to page 354, and the buyer will acknowledge the private road accessing the property is maintained by whatever association or cottage group or recreation group or property management group at whatever additional cost per month. So in those townhomes that have a very small maintenance fee and they're considered condominiums and they're literally just having their roads and their light systems and their paving maintained by a property management company, that's where your monthly fee would fall in. So that's a very similar clause to condominium, like a minimum condominium use. Underneath that, you have unregistered easement. You can obviously always set up an easement that's not registered if the other person beside you is a residing property allows you for a certain period of time, certain period of years, and you can have legal access obtained in writing. Water access is only accessible by the water, of course, and that's confirmation for vehicles and parking. For example, like island properties, you can utilize that clause in that case as well. Okay. Now we'll look at page 356. You have road access to public highways. This clause has to be approved under the Public Transportation Highways Improvement Act. You can never have direct access to the highway without it being approved by the Act. So the minister will have to approve this. So this is further conditional. Further conditional. Okay. And then we'll look at clause on page 361. I see 345 here. So 345 on the book page, it's known as water frontage, shore road allowance, unregistered easement. So this would be a situation that's obviously registered and scheduled and built up between two owners. This is already arranged by the previous seller for you, and it's confirmation of what the access is and when it is and by what date. Can we have this written in writing that unless it's promised and agreed upon, we can get out of the deal, and of course everything is returned to you and you can walk away. There's an acknowledgement clause right underneath it, so just for acknowledgement, and the one underneath that for shore road allowance with encroachments, same kind of idea. It's just really an acknowledgement clause that can be utilized for that case. So that's a quick overview and understanding of clauses and how they operate. And if there's any other questions you have, of course, send me an email or give me a call. Thanks.